Hi, everyone. Welcome. So, today we are going to be talking all about filing for your stepchildren. Okay. We've talked about filing for your biological children, filing for your adopted children was last week. And this week we are going to be diving into filing for stepchildren because there's so many, little rules that you need to be aware of so that you do not make certain mistakes or wait too long. All right. So that is what we're going to be talking about today. If you don't know me, I am attorney Lilian Chukura. I'm a US based immigration lawyer, and I help my clients get green cards and citizenships for themselves and their families using the US immigration law system. So if you would like to join my community of informed immigrants, you can do that by subscribing, liking this video, sharing this video. If you would like a private consultation with me, you can do that by going to my website, lilylegal.com, or by calling my office at 508-443-1788 and scheduling a strategy session where we talk about what you qualify for or what your family qualifies for. So let's start. All right. You want to file for your stepchild or stepchildren, and you want to know what is the process? Can I even file for them? If they're over 21, if they're under 21, when we got married, I'm going to go over all of that. All right. So let's start first with when did you get married to your spouse, right? So in a step parent relationship, there's a biological parent and you are the step parent, and you are a US citizen or permanent resident. Does not matter, right? You just have to meet the requirements of that child being considered your stepchild for immigration purposes. All right. So there's the step parent stepchild relationship in the real world, and then there's the stepchild step parent relationship in immigration world. So today we're going to be talking about it in immigration world. All right. So for that relationship to count for immigration purposes, for US immigration purposes, you, the step parent, had to have been married to the biological parent before the child turns 18. Okay? For you to be considered the step parent of that child for immigration purposes, the marriage between you and their biological parent have to have taken place before they turned 18. Right? That's what creates the relationship. Now, once you have that, then the rest can just fall into place. All right. So, what do I mean by marriage before 18? Exactly that. So, if you get married to the parents, let's say on the child's 17, they're 17 and a half years old, it still counts. If you get married to the parent the day before the child's 18th birthday, it still counts. Okay. You just have to make sure that they are not 18 years old yet. So if you get married today and tomorrow they turn 18, that's fine. Right? That still counts. So when I say married before 18, I do mean married before 18. All right. Because once they turn 18, you marry the parent. So in the real world, they are still your stepchildren. In immigration world, they are not. So it's really important that you pay attention to dates if eventually you would want to file petitions for your stepchildren. Now, if they are in the US or outside of the US, the same rules apply when it comes to that, when did the marriage take place, right? So if the children are outside of the US, you will just go through the same process. Once you can establish that you got married to the parent before the child's 18th birthday, you can now file an I-130 for the child. If the child is under 21, and you are a US citizen, they will be considered an immediate relative of a US citizen, which means that is the fastest processing time out there. Okay? Excuse Excuse me. So if you are a US citizen, you're filing for a stepchild, and they are under 21, they are considered your immediate relative, which means they get the fastest processing time. So you want to do, if they're 20, you may want to get that filing done so that they will be considered immediate relatives and their age can be locked in. All right. If they are already over 21 and you're just getting around to filing for them, just know the rules that apply for US children of US citizens over 21 would apply to them. If they are married, same thing. So, speaking of marriage, if they were married before, let's say they're 16 years old. Let's say they're 16 and they got married before you married their parents. Unfortunately, they will not be considered stepchildren for immigration purposes because they no longer counted as children once they get married. So again, real world, they're still children. Immigration world, they're not. So it's really important that you pay attention to those. Now, how do you actually go about filing for them? If they are in the US, let's start with that. If they are in the US and they came in with a visa and they're under 21, you can go ahead and file for them just like you would any other child, right? You can file an I-130 and the green card application for them in the US. Because they came in with a visa, they do not have to leave the US to get their green card, right? If now they are over 21 and in the US, the question becomes again, are they in valid status? Because if, let's say, they are on a student visa and the student visa is still valid, you can just file for them. As long as you can file an I-130 for them. They can wait for it to become for a visa to become available, and then they can get the green card. But again, those take about, right now it's taking about 7 years for unmarried children over 21 to get a visa. So just know, if they are physically in the US and they're waiting out that 7 years, they need to be in valid status for that 7 years that they're waiting for the visa to become available. So that's always the tricky part there, right? So that's where, if they're in school, if they have a student visa, then look into OPT, look into master's degree, PhDs. Depending on their career goals, that may be the steps that they need to take to get to their career goals, but that also keeps them in valid status by having that student visa valid, so that once a visa becomes available, they're able to go ahead and apply for a green card. All right. The same thing if they are married. Those are taking about 13 years. So that's 13 years if they're physically in the US of being in valid status. If they are not in valid status, when the visa becomes available, they're going to need a waiver. They will need to leave the US, get the green card, and then come back in. All right. So it's really important that you have that discussion. If they're in the US, they haven't violated their status yet, and they're not sure if they can continue going to school or continue maintaining their status. It may, you may need to have the conversation of maybe you should leave the US and wait out this visa. All right. Now, if they are already outside of the US, again, same process. You file an I-130, you wait for that to be approved, then you wait for it to be sent to the National Visa Center. You do the visa application. Again, if they are children under 21, that is the fastest processing time. So they will, because again, there's always a visa available, right? That's why I say it's the fastest processing time, because there's no wait time for a visa. Immediate relatives of US citizens always have a visa available. It's just a matter of how long is it going to take USCIS to process the I-130, MVC to process the DS-260, embassy to schedule the interview, you to attend the interview and get your visa, right? So that's really the wait time for immediate relatives of US citizens. Everyone else, have to make sure that the visa is immediately available. If a visa is not immediately available for their category, then there's a lot of waiting, right? So when I say you go through the National Visa Center, the embassy, that is once a visa is available for your category. So immediate relatives, children under 21, visa is always available. They can just wait for it to be processed, interview scheduled, and they can come to the US once they pass the interview and get their visa. Children over 21 or married children, there's no visa immediately available, so they still have to wait for that visa to become available. Like I said, those are taking about 7 years for unmarried children over 21, and then married children. Um, it doesn't matter your age, as long as you're married. The processing time right now is about, for a visa to become available, it's about 13 to 14 years. So it's so important that, conversations are had, and expectations are set when you're starting this process, because um it can be so hard for your child to know that, okay, there's something filed, but they're waiting, it's now 2 years, 3 years, 4 years, nothing is happening, and they may start questioning whether you even filed for them. Well, just remind them that because they're married or because they're over 21 when you filed, it is going to take time because there's no visa available. So then, you may need to set expectations for your children over 21 and your married children. And then for children under 21, that you're filing for, you may need to set the expectation that it is going to take time for it to go through the different agencies and the different steps to get to them actually getting the visa and coming to the US. It is a long process when they're outside of the US because, again, they want to be with you, right? They want to be with you and their biological parent in the US, and building that relationship. But it's definitely very hard on everyone involved. So just setting those expectations really does help. Okay, it really, really does help. So always make sure that you're setting those expectations so that they don't assume that, because I have seen this happen where there's an assumption that maybe the application wasn't filed, or some children were filed for and others weren't. It's just the processing of the applications are different depending on the age of the children and their marital status. Okay. So, children under 21, I-130, DS-260, interview at the embassy, get the visa, they can come into the US. All right. If they are over 21, I-130, then you wait for a visa to become available, then DS-260, embassy interview, then they come in with a visa. All right. The same for married children that are outside of the US. So it's so important that you pay attention to the ages of the children, because once they pass 21, it's going to take way longer. So it's better to not delay. It's really better to not delay. So if, let's say, for example, you get married to your spouse and they have a child that is, let's say, about to turn 18, and you got married before they turned 18, right? Now you want to file for them. And, there may be some things going on in your own lives that just you weren't able to start the process right away. And now they're like, 19, 20. Make sure that you file the application before they turn 20. Before they turn 21, I'm sorry. So file the application before they turn 21. Because in most cases, depending on how long things take to process, their age when you filed can be locked in. Okay, so their age when you file for them can be locked in. So if you file before they turn 21, that age can be locked in, so that even if it takes, a year for USCIS to decide on the I-130, and now the child is 21, because you filed before they turn 21, their age can be locked in, and then they can still go ahead and start the embassy stage. They do not have to wait for a visa to become available because you made sure to file before they turn 21. Again, it is so important that you do that, because you really want to lock in their age. It just makes it easier. And then just remember, the age they were when you got married is the key. Okay, if you know they're turning 18 in a month and you can get married before they turn 18, go ahead and do that, because that will just make the process a whole lot easier on everyone. So what happens, because again, this is real life, right? What happens if you got married but they were already 18? So technically they do not count as your stepchildren for immigration purposes. How can you get them to the US? Well, that's where your spouse comes in, right? Their biological parent comes in. So if their biological parent is a green card holder or a US citizen, they can file for the child. So once they get their green card, if you're also filing for them to get their green card, so once your spouse, their biological parent, gets their green card, as long as they're still under 21, right, your spouse, once they get their green card, can file an I-130 for their child. Wait for that to be processed. They go for their interview at the embassy, and then come into the US with a green card. If they are physically in the US, with a visa, and the visa is still valid, right? If they came in with a visa and the visa is still valid, when your spouse becomes a green card holder, your spouse can technically file for them to get their green card in the US. However, like I said, the visa must be valid, which means they have not overstayed their visa. All right. So when I say this, people are like, oh, yeah, I have a 10-year visa. Well, just because you have a 10-year B2 visa does not mean you get to live in the US for 10 years. Okay. When you come in on your B2 visa, there's a stamp that says how long you can stay. And most of the time it's 6 months or less. All right. So if the child comes in and they still, 6 months or less, and the spouse has the green card, they're able to file for the child is still in valid status, then they can go ahead and file the green card application in the US. So it's so important that all the moving parts, all the moving parts, because again, if they're physically in the US, valid status is a must, unless they count as immediate relative of a US citizen. All right. So if they're over 18, but under 21 and in a valid status, just know, if you do not count as their step parent, their biological parent, if they just have a green card, can still file for them as long as they maintain their valid status. And they can switch from one valid status to another. It's called a change of status. So you can also do that. So if someone comes in on a B2 visa and before the stay expires, so if they were given 6 months before the 6 months expires, they apply to switch from the B2 to an F1, which is the student visa. If that is approved, they are allowed to stay in the US and go to school and do all the things that an F1 student can do. And once a visa becomes available and you're able to file for them to get their green card, you can do that because, again, they're in valid status. So that's a way that you can, make sure that a child maintains their status while they're going through this process is by maybe switching them from one valid status to another. And a student visa is a great way of doing that because they get to go to school. They get to basically pursue a degree, pursue a career, and are able to still maintain status and get their green card. All right. So, quick breakdown. All right. Just to recap, if you are a US citizen or permanent resident and you are getting married to someone that has children and you want the children to be considered your stepchildren for immigration purposes, right? For immigration purposes, you have to marry their parents before they turn 18. So before the child turns 18, you have to marry the parent. Even if it's, the day before they turned 18, it still counts. Okay. Even if it's the day before they turn 18, it still counts. So once you do that, you can file for them just like you would any other child. Right? If the child is under, if by the time you want to file, they're still under 21, they're in the US with a valid status, or they came into the US with a visa, you can still file for them. Even if they're outside of the US, you can still file for them. So basically, once you're able to establish that they are your stepchildren for immigration purposes, US immigration will treat them just like any other child, right? They will treat them the same way that they will treat your biological children. So the same rules would apply as far as, how old they are, if they're considered immediate relatives, when a visa is available, all those things. The only thing that does not apply to them is being able to automatically get citizenship from you, right? So typically, there is a process by which if your parent is a US citizen and you come into the US and you have a green card, you're in their legal and physical custody, and you're under 18, you're able to automatically become a citizen. That does not apply in the step parent situation. So if you got your green card from your step parent, you will not automatically gain citizenship from said step parent. Okay. If your biological parent becomes a US citizen, that's a different situation, but the step parent cannot pass on their citizenship to the child. Only biological parents and adoptive parents can do that. So I just wanted to flag that. So even though the same rules of applying for green card that applies to biological children apply to stepchildren, there is that special rule about being able to get citizenship that is different. All right. So that is all I have for you today. If you have any questions, as always, please put them in the comments. I do go back and respond to those. If you found this video helpful, please like it, share it. And of course, subscribe if you are not already. And we just want to make sure that you are getting correct information. You are being informed as we grow our community of informed immigrants. I just want you to know that I truly care about you and your immigration journey. So please ask me questions. Schedule a strategy session if you want to make sure that you meet the requirements and you want to know what the next steps are for you to file for your stepchild or for your biological or adopted child. Okay, feel free to reach out. You can do so by going to my website, lilylegal.com, or by calling my office at 508-443-1788. Once again, thank you so much for joining me. I look forward to your questions. Put them in the comments, like I said, and I will see you next week. As always, I am Lilian Chukura. I'm the owner of Lily Legal, where we help our clients get citizenship and green cards for themselves and their families using the U.S. immigration law system.